morning, everybody. We appreciate you taking time out of your busy schedules to join our webinar, and we hope you find this webinar informative and beneficial. I am Evelyn Blanco, and I work with Outlook HR as an HR advisor. Want to let you know we will be recording the webinar, and as always, all attendees will receive the recorded webinar and presentation. Please remember to put any of your questions in the Q&A box, and we will make every effort to address these questions during the webinar. A little bit about myself. I have been in the HR discipline for more than 20 years. I am bilingual Spanish. Because of my extensive experience, I am able to guide and support my clients with practical implementation and reasonable implementation while keeping all areas of compliance in place. I have pretty much seen and heard just about everything, as well as my esteemed panelist, Robert Huddock, has as well. Robert has over a 20-year law career. He's dedicated the past 15 years specifically to representing employers in employment law matter. Rob also provides employers with employment law education and solutions to protect themselves from claims and navigate workplace challenges. So today we're going to be discussing recruitment and how to legally interview. Our agenda will be covering recruitment policies and practices, making sure that you have compliant applications, interviews, do's and don'ts, references and background checks, employment testing, and risk containment. So with that, Robert, I'm going to pass the baton over to you.
Thank you, and thank you everyone for attending the webinar today. Let me just jump right into providing some of that education that Evelyn just mentioned. She just mentioned some topics that we're going to be covered. And what I want to mention is these are the topics that or subjects that most often come up in the area of, we'll call it hiring. There are a number of issues that fit into the hiring category, but the issues that most frequently come up with respect to hiring are the recruiting. That's things like job postings, hiring criteria. That's things like education, appearance, English fluency. There are inquiries of applicants, both in interviews and in any application form that you might have. There's background checks such as criminal and credit history and other types of checks. And there's also tests and health examinations. So what I want to talk about first is policies or practices can be in written or unwritten form. The written can be formal or informal. Such as formal statements of policy or practice, job postings, interview guidelines, outlines, questions that you ask, even in email. Let's say, one person writes an email to another saying, hey, we have to make sure we get this type of person. We don't want that type of person. Or text messages, similar thing. Can be unwritten. It can be, for example, sometimes there's like what individual people anyway think is a common understanding of, what the company wants and doesn't want. Or there could be a discussion between a supervisor and an interviewer, something like that. So I'm mentioning these because these are the things you should have on your mind as evaluating when you think about hiring practices. So again, the types of evidence that might come up if there were an issue. It could be internal statements of policies, practices, procedures. Could be job postings. And as I mentioned, this could be direct or indirect statements or discussions regarding criteria, standards, or evaluations. And then, of course, written or verbal communication with candidates, applicants. I just want to briefly mention what the law says is the standard to serve as a background for what we're going to discuss. And so the standard for recruitment practices, and recruitment practice is unlawful if it restricts, excludes, or classifies individuals based on a protected category. I want to emphasize that. It's going to be in each one of these things that I say. Expresses a preference for individuals based on a protected category. Communicates or uses advertising methods to communicate the availability of employment benefits in a manner that is in, I guess what the law says is intended to unlawfully discriminate based on a protected category. The reason I emphasize that is there's such a thing as legal discrimination, and then illegal discrimination is one that's based on one of those protected categories that's within, for example, the California fee act. These are age, national origin, disability, and so forth. And so not every category that an employer might want to include or exclude is necessarily unlawful discrimination. I want to emphasize too that problems can arise both from direct things, such as asking on an employment application if someone has had workers' compensation claims before, and it could be indirect, such as salary, let's say, where if there's information, well, that's a bad example. I'll tell you why later. But it could be appearance requirements, because those could potentially implicate gender discrimination. Now, I also want to differentiate between, in discrimination cases, there's something called disparate treatment and also disparate impact. The thing that we're going to focus on here is disparate treatment. And that's when you treat one individual different from others. Disparate impact is when something doesn't necessarily have a direct effect on one individual, but to a statistically significant degree, it has an impact on the whole category. The reason we're not going to focus on impact is because you need to be a relatively, you need to have, I'll just throw out a big 100 employees or more, so that there can be a statistical significance. And so I'm going to assume, or at least for purposes of this webinar, that we're not talking about a huge number of employees. And so some of these things that I'm going to talk to you about become directly relevant only in disparate impact cases, but it's still good. Let's move on right to job postings. And there is a specific law on job postings. The general standard here is it is unlawful for an employer to print or circulate any publication or make any non-job related inquiry of an applicant verbally or in application materials that expresses, directly or indirectly, like I just said, any limitation, specification, or discrimination as to any protected category. And here's another fundamental thing I want to mention. If you have a qualification or criteria that you want to, let's just say you want to have, or you need to have in your hiring questions or applications, what you would need to show is that that qualification or criteria has sufficiently direct connection to to a sufficiently specific job requirement. And you also need to meet what's called the business necessity test. They're kind of interrelated. And the idea here is that you, for example, you can't necessarily say, okay, this person has this type of criminal history and we don't want criminals. And this is California, don't forget, so it gets a little crazy. But here's just one example is, we don't want people with any criminal history. And, and it doesn't have a direct relationship. Whereas if someone has a conviction history of a crime of dishonesty, fraud, or whatever, and you're a financial institution, then you'll be able to show those things.
So Robert, can I ask you a question? When you're talking about the requirements, so for example, if I'm recruiting for a plumber, on there, would we put the essential functions of the job that you have to put, you have to be able to walk a construction site, climb under buildings, those sort of things. Is that legally compliant for a job posting?
Yes, because what you're reciting there is directly related to the job functions. And actually there's some law on the fact that you can specifically on essential functions.
Okay.
Of course, what you're talking about is potentially implicating disability issues. But we do have specific guidance on that specific issue. And I'll mention one more thing fundamentally. A lot of what we're going to talk about today isn't necessarily from any particular statute. And then, normally what we rely upon to give us guidance is health cases that are published. There's not a lot of cases that are published in this area. So a lot of what we talk about is simply our best educated opinion on the kinds of things that might implicate protected categories.
Okay, we do have a question, and they're asking, what about requiring a high school diploma? Now, would that go directly to what the job requires?
That's the kind of thing. Well, let's put that question on hold because I'm going to review that subject.
Okay.
And the more specific question, we can, of course, get to it.
Okay, perfect.
We're going to talk about criteria that's potentially discriminating. And we'll kind of just go through the list. And that is, the first is age. And as I mentioned the example before, using salary as a basis for differentiating among employees is potentially discriminating if it adversely affects older workers as a group. And so this is one of those disparate impact situations. Mm-hmm. And obviously higher salary could mean older people. But it's not necessarily going to show in any individual treatment of one versus others in terms of age. Hope that makes sense. Now, how about overqualification? We're not going to hire you because you're overqualified. It's not necessarily by itself something that gets you into dicey territory. But if you're using qualification as a pretext for age discrimination, then it starts to cross over into things that you want to avoid if you can. That makes me think of one other practical thing to relate. And that is, there's the law and the technical aspects of the law. And if every employer were to try to 100 or, really err on the side of caution as far as legal requirements, it's not something that is realistically feasible, probably. And that's in part because you also have to look at the practical things. So for example, maybe there's interview questions that you want to ask that aren't directly or really closely tied to a protected category. Well, you're going to need probably some types of those questions in order to properly get the candidate in. What I'm talking to you about today is all the different things that could possibly come up so that you have an education on that and you can use your best business judgment as to, how you want to implement that, how you want to apply it.
let me ask you a question, since we're kind of on the subject. So typically when I was doing I started my career many years ago in recruiting, and I still do it sometimes, but I typically have a list of questions that I ask all the candidates that I'm interviewing for a specific position. Now, obviously in conversation with each individual candidate, they go down different pathways depending on what their responses are and such. Would you recommend that when you're hiring for a specific position, you stick to a script of specific questions for all of the candidates that you interview for that position?
It depends what you mean by stick to a script. And let me explain.
Okay.
It is a good idea to have standards with respect to interviewing, at least general standards. And
that's what I meant. Yeah.
Interview one person in a protected category different from anyone else. And that's particularly if you have multiple interviewers. Also, it is a control, if you will, on, not getting into things that could involve protected categories. Generally speaking, you can avoid the most the direct ones that are clearly directly related and could cause a crime. However, that does not mean that you have to sit and say, oh, where did you go to, where did you work last?
Right. You want it to be a fluid and a natural flowing conversation. That's how you get to know your candidates.
And that's what we're talking about right now. Okay. This is the education that I'm hoping to provide to you so that you can know on the fly what works and what doesn't. And so we were talking about overqualification, and the law does say this: overqualification can't be a pretext for some other, for age, for example. But it specifically says it's okay as long as the decision is based on at least one objectively defined criteria. So it demonstrates that it's not a pretext for any kind of age discrimination. And then similarly, there's years of experience. And this is where it gets a little crazy. It's like that's a very legitimate piece of information. So I guess my advice there is to, when you're asking about years of experience, think through ahead of time how that is directly relevant to whatever job you are interviewing or having people apply for. Because this is a perfect example of what I was talking about before. Some are just completely unrealistic, and the best practice is that to just keep it in your mind. Now, obviously, another category is gender, sexual orientation, gender expression. I'm not going to get into specifics on that at the moment anyway, because I want to make sure we at least generally cover a broad range of topics. Then there's citizenship, national origin, and ancestry. Now, in here, there are specific laws, federal law and California law, that speak specifically to this subject. And that, for example, under federal law, which applies along with California law and anything that California employers do, says that you can't discriminate, and this is related to national origin and citizenship. You can't discriminate based on national origin, lack of U.S. citizenship, status as I don't know if this is politically correct term to use in our climate today, but it is still used. So I'm going to say status as an alien admitted to the U.S. for permanent or temporary residence, or status as a refugee. And then the law goes on to say, but it's okay to prefer citizen over non-citizen if the two are equally qualified. And then California law, it also has national origin and ancestry. And one thing to note here, if you're properly doing actually, this is with respect to my next subject, and I just want to touch on this because it's a little bit tangential, and that is, and I may be stating things that people already know, but an employer cannot knowingly recruit or hire unauthorized aliens or continue to employ once known. And the thing it's very simple. The thing that'll protect you from that is getting your proper I-9 certification. Because as long as whatever they submit doesn't show obvious indications of not being legitimate, then that's what you rely on.
Right.
And now I also want to mention national origin. Remember, that includes, and this is right from the law, physical, cultural, or linguistics, the linguistic aspects of a national origin group. And those are things like hairstyles, facial hair, among others. But that's the idea. So let's get into the categories of physical abilities and mental health. That obviously potentially implicates the protected category of disability. So on that, an employer cannot have qualifications, tests, or other criteria that tend to screen out people with disabilities unless, as I said, it's directly related to the position and it's a business necessity. Employers in this area must also consider whether a reasonable accommodation would allow that disabled applicant to perform the essential functions of the job. And then this is something that is relatively well known. You're not going to want to do any kind of testing without a conditional job. But again, there is that exception even for pre-job offer testing when it is job related and a business necessity. But that is way too dicey to even go that route. Do the conditional offer and then get the testing. And you're going to have to show the same thing when it's post-offer testing. One that comes up that especially in our area is English fluency. Is there anything wrong with saying qualification for this job is you need to be fluent in English? Going back to the original theme, it must be reasonably related to job performance. Now, what the law says as far as nuances is a decision not to hire based on let's say an accent or an inability to communicate well in English is okay if the lack of fluency would materially interfere with job performance. If not, it's going to implicate national origin. And let's talk about a slightly different but related category, and that is, what about English only policies? Only English can be spoken in the workplace. As to those, the law says those are not presumed to be discriminatory. The requirement is that they must be narrowly tailored and be a business necessity. And you must give notice to employees or applicants of the policy and the circumstances and time when it's required. And that goes back to narrowly tailored and any consequences of violation. That's what the law requires with respect to such an English only policy. Now, we'll get to that education. It is okay if the job demonstrably requires that educational level. And you're going to be able to justify that in most circumstances. But what the law says is not okay is if that requirement, and this is from a case, and it's incredibly vague, which is like a lot of other things. But a case says it's not okay if it operates as a built-in headwind against minority groups. And what I can say as to the meaning of that is, as long as you have that, related to job performance, at least generally, business necessity, and you don't have other indications of any disability, any requirements that you have, let's say, in inquiries or applications that are not at least somewhat obvious about how the education is trying to get at, the age of the person. As long as there's not anything direct, you're going to be okay with respect to that issue where it's how many years of education.
So for example, if we're talking about, if we're talking about education and we're talking about like an unskilled laborer, somebody on a construction site, requiring a high school diploma wouldn't really be justified. Am I right?
But remember, the issue that you're looking at is, does it, again, you're looking at age here when we talk about education, right? It's looking at information that may indirectly show that you could be trying to get age information to discriminate on the basis of age. And I think in that situation, you're not even getting close to it.
Okay.
You'd be able to justify it. It's just a matter of articulating what the justification.
Right. Okay. So I get what you're saying. So going back to the person, Nicole, that asked the question about the high school diploma, she's talking about a warehouse position. So it's not necessarily related to the common categories that are implicated. She's just saying, can she require a high school diploma for a warehouse position?
Yeah, so that's an example. And just to give you an example of what an articulation might be is, there needs to be, effective communication, within the workplace. And so, and this is just me off the top of my head.
Sure.
You could say that, if you've got totally differing levels of education, it might affect communication skills. And again, that's just a example off the top of my head. You just want to think about ways in which, and you can be creative, and you can think about, okay, what does a high school education do? It can be like I just said, communication skills. It can be, understanding of instructions, those types of. So I hope that answers the attendee's question. And if not, I'm always available to answer more specific questions.
Perfect. Thanks, Robert.
Okay, let's talk about another one that's specific. It's not necessarily with respect to protected category, but there are specific laws regarding it, so it's important to review. And that is financial circumstances. For example, you can't discriminate or have a criteria and not hire someone because of the fact that they've been in bankruptcy, they've done a bankruptcy previously, that they were insolvent before bankruptcy, or that they didn't pay the debt in connection, like anything that was ruled to be paid in connection with their bankruptcy. So basically anything related to bankruptcy. And so that's not a question you're going to want to ask on an employment application, for example. That's direct by statute. Now, indirect by case law is, for example, wage garnishment. And what the law says is it really doesn't have a correlation to job performance, generally speaking. But if you can show it's directly related to job performance, and there's a business necessity, then it's illegal. And then again, going back to the disparate impact and the kind of the scope of things to consider that are potentially a stretch, potentially is, some of the law says minorities may be disproportionately in debt and at the lower end of an economic scale. But again, this is with respect to disparate impact claims. And for those who have, say, 100 or less, it's just a number off the top of my head, there's not going to be a legitimate statistical significance to be had. Unless, you've got, 10 African-American employees, all 10 of them, and then the other 90 were treated differently with respect to financial circumstances. But what is the realistic chance of that? Let's get into another one that comes up somewhat often, and that is dress and appearance requirements. Now, again, we're talking about protected categories. And so you got to keep focused on. So you got to look at, for example, here, dress and appearance requirements that treat, for example, women and men differently, or implicates age in some way, implicates disability somehow. So let me give you kind of some guidance on the nuances here. Facial hair is a good example. Just one particular case out of the blue, but it would involve the police department that had, no facial hair, can't have any facial hair. Well, that's upheld as okay. You don't necessarily, you could establish that it's in some ways directly related in business necessity. But for something like that, I wish I could tell you more specifics, but it just doesn't really, the specificity isn't really all that available. It's basically looking, professional and looking uniform with respect to, public facing people. And I'm just giving an example. However, what we do have guidance on the fact when a no facial hair policy could be potentially discriminatory, and that would be religious issues and whether they have beliefs about facial hair, for example. And there's also some guidance on race. And the one I've seen is that they use an example of African American, and they have a specific common skin issue sometimes, and they, and so in that sense, if you said, well, you can't have facial hair, if that's something common to the race, and and this is even if it's a company or the organization-wide policy. In certain instances, you're going to have exceptions for people that where directly implicates a protected category. If a religion has a well-known belief about facial hair and that they have it, then that's something where you're going to need to make an exception. And so getting over to like talking also about dress and appearance, go back to what I said about cultural aspects that could implicate race and national origin. That's and some examples, dreadlocks, and that's even potentially religion, because it's Rastafari. And then one case even addresses hair color. Remember, we're in California, and any requirement. In this case, involved a requirement that folks need to have their natural hair color. And in that case, an African American female was not allowed to have blonde highlights in her hair, but Caucasian employees could have blonde hair, even though that's their natural. It's just potentially discriminatory because you allow one to have it, whether it's natural or you don't allow it. And like I say, the statute with respect to this, when it comes to race, indicates that it includes hair texture and service styles. Grooming policy. This is a little bit different than facial hair because it could be, must have short hair, anything along those lines. And some differences between men and women, perhaps for obvious reasons, are not per se discriminatory. What the courts do in that instance is to weigh the burdens on each gender that is caused or potentially caused by that grooming cost. But again, there's obviously, there's going to be differences sometimes in grooming policies because, for men, traditionally speaking, you're going to be talking about short hair. You're probably not going to require female employees to have short hair like men do. I'm speaking independent of our climate today with respect to gender. This is still legitimate.
Robert, just letting you know we're at 20 minutes till, so.
Yeah, let me adjust to that. Dress and appearance, clothing, direct by statute. You can't include pants based on gender. You can't have a pants only policy for all employees. And here's one that on a subject I just talked about. Employees are allowed to dress consistent with their gender identities because gender identity is a protected category. So to put it in one more level of detail, you can't require an employee of one biological gender to dress according to traditional gender appropriate clothing. And that's one of the case. Let's adjust. Oh, there's that. You may know about this. You can't discriminate on the basis of the fact that, or you can't ask about necessarily whether the applicant or employee is a rehabilitated former had rehabilitated former alcohol or drug abuse. Obvious different is a whole different story. All right, so let's talk about applications and interviews. Applications don't have any required format, but you cannot seek information that is potentially unlawfully discriminatory. And on that, you don't want to ask questions about what could implicate age. That would include potentially years that they graduated from certain educational programs, because that could suggest age. But again, you got to be there's a certain rule of reason. It's way out there for California, but there is a rule of reason. And so it's direct or indirect. Indirect would be years of graduation. Employers who are, for example, subject to EEOC reporting requirements can gather information about race, gender, national origin, and such. But obviously, you can't use that in employment decisions, and you have to keep any information separate from the employee's personal account.
And should be done after hire, correct?
With done whatever.
The EEO's information, no, they can't ask it as part of the application process, but the person can decline to, the candidate can decline to answer, right?
Yes. Yes.
Okay, so we have a great question here. What do we do if they bring up any of those categories on their own during the interview?
Yes. What you need to do from a technical standpoint is, and this is one of these things that sounds a little crazy, but if someone brings up anything directly or indirectly that indicates one of the protected categories, the guidance is to kind of immediately jump in and steer the question away. And one way you would do that is, okay, someone says, I have 3 kids and I had them 3 years after I graduated from college in 1992. Well, you just want to jump in there and not, the guidance is with anything that might even indirectly do it, and say, oh, let's not talk about that. We don't make decisions based on, anything like that. We evaluate an employee's qualifications.
So for example, if in an interview, if we're in an interview and this goes to a conversation I recently had that somebody says, oh, I went to St. Joseph's High School. I did too. And they say, oh, I graduated in 80, whatever. And I say the same thing, that I should not go there. I should say, oh, I also attended St. Joseph's. Great, move on. Do not discuss years, steer away from that. Or even if they volunteer, I have a 7-year-old, they're starting 2nd grade. Don't discuss it. Just, oh, that's lovely, move on.
Yeah, sadly, in my humble opinion, it's sad.
It is.
You're not supposed to have that conversation. And one of the reasons I think it's unfortunate is, I'll speak for myself, and I know a lot of other people, they want to have a real human conversation with people because that's part of the evaluation of whether they're
exactly. It makes it so difficult to get to know somebody a little bit.
Right.
Yeah, it's very true.
And again, I guess I'll give the same kind of general guidance that I gave before, and that is, apply a rule of reason. If they volunteer information like that, then, you can just, say, oh, okay, but you're not going to want to further facilitate such a conversation.
Right.
It's when it gets into really direct things that you definitely want to jump in and steer it. Okay. So I hope that answers the question.
Yes. Yeah, it does.
Okay, so we're at 10:45. So I'm going to jump down to risk containment, and we've been talking about some of this stuff.
I do have a couple more questions on interviewing that I think are going to be important to the audience. Given that we're in such a strong such a prevalent time of remote working, what is the proper or best way to approach childcare? Or how do you, so somebody mentions, oh yeah, I have a 3-year-old. Okay, so what can I ask them about what arrangements they have made since they are working from home for their toddler or whatever, and they volunteered the information of having 1 or 2 children, whatever the case may be.
Whether they volunteered it or it's somehow asked about, I'm going to go back to the general rule of thumb. If they have a direct and reasonable connection to a job qualification, and there may be a business necessity. It's dicey, but I'm just telling you the actual application intellectually. So, unless it's absolutely, you don't want to have some kind of vague connection to the job. But and I can't think of an example off the top of my head, but if you're gonna be asking about that, think about how you can get the information in perhaps indirect ways that's not so blatant. And also think very carefully about a strong connection to a job requirement.
Okay. I just got one question, and prior to that, I was thinking, is it acceptable to have a policy as part of the initial communication with the candidate and or prospective employee to say, you know, it is the expectation of the company that our remote workers have a distraction-free workplace with private. Okay, because that's exactly what one of the panelists said is, can we ask, do you have a distraction-free workspace, a private space with a door?
It's the example of both things. It's an example of how you ask the question without getting into dicey territory, because it's not direct for sure, and it's also a reasonable job requirement.
Perfect.
Yes.
Okay, thank you so much.
And so risk containment, ways you can try to avoid these things beyond what we've kind of already talked about. Strategies, if you will. For this reason, for this subject and other subject, it's always good to have a checklist of terms of employment and stick to it. Also, similarly, job description. That's going to allow you to stick to what the qualifications are, and also, it provides some uniformity with respect to, for example, interviewer to interview. And then this is a kind of tangential one, but you want to have written at-will provisions. That can potentially be a defense, not all that strong in California, but going back to something we talked about before. Good idea to prepare and use pre-prepared guidelines for use across all interviews. It doesn't mean you can't go off, and have at least somewhat human discussion, as long as going in, as long as you maybe train people as to what are the obvious kinds of things that you don't want to get into. And people can use their judgment as they go through the interview. But irrespective of that, if you have a checklist or job qualifications, that's going to be a defense. And
yes, we have a question. What are the right questions to ask about reliability? They're still having a hard time finding reliable employees. Joanna, can you tell us, is this referring to like reliable transportation or just showing up? Because I've had clients with both issues. Showing up.
And showing up to work.
Yeah. Yes.
And did you say disability in there?
No, reliability.
Oh, reliability. Well, neither reliability in general, nor being able to get to work is, in my opinion, far from implicating any protected category.
Yeah, but she's asking what are the right questions to ask. So honestly, and in my experience, and we skipped over it, I still am a strong believer in getting references from past employers or people you've reported to. What are your thoughts on that?
Okay, and so getting back to that other question, what are the right questions to ask? Do you have a reliable form of transportation?
Yeah.
It's really as simple as that, because that question, and it should get you the information that's sufficient for your needs.
Mm-hmm.
If there's other specific things, both Evelyn and I are available to discuss any more specifics of that. And by the way, I'll speak for myself. If there are questions that are coming in that go beyond the 11 o'clock drop dead time, then I think
we can stay a few minutes.
Yeah. What was that question that you just asked again? after the
So-
transfer.
So the next question is, what are your views on punctuality?
Well, I have views on punctuality, but they have nothing to do with protecting capital.
Okay, so it's fine to say that. Okay,
Be punctual?
yes.
Absolutely. Just tell you
Now, what
something.
about when they have childcare issues they're asking?
I'll just tell you something in that regard. I've actually had a case that involved whether punctuality is a legitimate, non-discriminatory reason for cases for instances of a discrimination. And there's law out there that says punctuality is inherent in any job, and therefore, and we settled it just before a very low amount because it was clearly going to be a summary judgment. So please continue.
Okay. So what if they have childcare issues?
That's a little general. And let me be more specific. Like, is that asking about it in an interview? Is it someone who demonstrates that they have childcare issues? Because the analysis is different.
Right. Okay.
So the interview applications and such, I would not ask about that directly. It would be more along the lines of these general questions that we've been talking about. So, and here's one: we expect you to be working from this hour to this hour?
Right.
That's completely
Okay.
Generic, but it's the information that you might need to get at the same issue.
Okay. So we've got quite a few questions, so let's just kind of go with this. So we have somebody that said, I'd like to hear a response to the references questions and what weight they should hold or whether they are a best practice still. Should people do references?
So references can be dicey in the sense that, and there's been some claims with respect to this. But in our context, let's say the reference in some way implicates a protected category. This is in this context. Then you might, without any direct prompting of it, you could still be in put yourself in a dicey situation, because then you have to maybe adjust your criteria or do a little extra. And by the way, interviews, good thing to take notes. And then also good thing to ultimately, and this doesn't have to be specific, but say something about the decision.
Right.
So with respect to reference checks, what I see as the more prevalent issue is giving them, it's a good idea not to give them, because it just provides an opportunity to someone who doesn't get hired at this job from which they're asking for a reference to be able to make hay out of it, as they say. And along the line of references, there are certain, for our purposes now, that's my take on the question. And then, of course, also we have criminal history and credit history. And all I'll say on that is, number one, better for post-conditional offer. And number two, you don't want to have, because you can get investigations into almost anything. And keep it, like everything else, keep it to things that you could demonstrate are directly related to job criteria qualifications.
Right. So typically going to references, I always, tell people just verify dates and title, because at least then that the person did in fact have that job for that period of time. So at least they're being honest on that. And typically that's what most employers now will only do. So at least you have some confirmation of actual work history. Would you agree with that?
Yes, that is precisely what and I know my colleagues put into settlement agreements when the former employee, wants to protect against bad references. And that is, if anyone calls so and so and so and so for a reference check, the information given will be like what you just said.
Dates and title only.
They were in this position from this time to this time. And what you say to people and what you actually use is a company policy that you only give that information.
Right.
Because
that's the company.
Right. Because then it's not a thing about singling out anybody and treating somebody different in certain cases.
Okay.
And by the way, criminal history is a subject, and how to handle it, and credit history inquiries are subjects in and of themselves, because the requirements are specific, they are many, and you need to follow them to the T.
Great. Thank you, Robert.
Anything else coming up in questions?
No, that's all we have for now.
Yeah, and I also spoke about some of these other risk containment. Oh, and just like with any job qualifications or anything, there are certain forms you can use, and basically it's to support your position. Can't get into them now, running out of time. But again, Evelyn and/or I are available to discuss things like that if you're interested in specifics.
Any more questions from our participants? Okay. I want to thank everyone thank you so much for taking the time to join us for the webinar. We do hope it was informative and beneficial to each of you. Please do keep in mind that Outlook HR as well as HUDEC Employment Group are here to assist. We do provide training in best practice interviewing skills, the do's and don'ts. As I was speaking with a colleague yesterday, even an HR professional like myself, we learn every day something new about what should and shouldn't be done with interviewing, the best way to handle certain situations. So it's always important to stay on top and abreast of new and best practices. And it is difficult to stay within the legal bounds, so we must keep learning. We also assist with development of job descriptions, so please don't hesitate to reach out. We're here to help. Robert HUDEC, thanks again once more for joining us and for educating us on all things legal with this very, very complex issue. And it looks we have, somebody is just saying, thanks so much for all the info. Greatly appreciate it. We hope you all have a wonderful rest of your Wednesday, and we look forward to our next webinar and having you all attend. As promised at the beginning, we will be sending out the presentation and a link for the recorded webinar. Have a wonderful day.